Hello, and welcome back to The Silent Pandemic, the podcast that shines light on the quiet but powerful stressors that impact our lives, and more importantly, how we can empower ourselves to tackle them. I am Vaishnavi Yadav, and today marks our second episode State Planning in Action. We are honored to be joined by a remarkable guest, Advocate Mansi Bhushan, the founder of the Chambers of Mansi Bhushan. Under her leadership, the Chamber has built a reputation for ethical, transparent, and timely legal counsel across a broad spectrum of areas, ranging from civil, criminal, and matrimonial disputes to real estate, corporate due diligence, taxation, and constitutional matters. What's specially compelling is Ms. Bhushan's journey. A law student who consistently topped her class at Government Law College, Mumbai, served as General Secretary of her college's Legal Aid Committee, and authored her path into independent practice with passion and precision. As a panel lawyer with the Delhi Legal Services Authority, she has further refined her approach to serve all strata of society, bringing legal empowerment to those who need it most. Today, we pivot from the technicalities of law to its lived reality. State planning is often dismissed as paperwork for the distant future, but it is really about the human stories woven across generations. Planning for the well being of loved ones, protecting legacies, and navigating emotional truths that cannot be reduced to documents. So, with that in mind, I am thrilled to welcome you, Ms. Bhushan. Thank you for being here.
Thank you for having me on board, Vaishnavi.
So let's start from the very beginning. You have built an impressive legal career across diverse areas of law. Can you briefly share what led you to practice law?
So the story is quite funny. I was initially during my school days didn't have a clue as to what I want to do. I belong to a science background. I belong to a family of teachers where none of us had any exposure of courtrooms or lawyers. But a distinct relative of ours was a lawyer and he was working in a law firm. And we happened to visit them when I was in class 8th. And at that time, I saw that, oh, they have a really good lifestyle. And that's the impression that I gathered that lawyers are usually the affluent class. And once you become a lawyer, you get to earn a lot of money. So, again, this is a very childish notion with which I thought I would start the law. But when I started preparing for CLAT, which is Common Law Entrance Test, in my class 11th, I enrolled for a 2 year coaching with one of the institutes. And at that time, when I started studying as to what the questions were, especially the legal aptitude, I found it to be very interesting. Those are questions pertaining majorly to contracts or torts. And those I found out that they are mostly based on common sense. So if you are good in common sense, if you apply your mind, you'll come to the right conclusion. And that's what our law is also all about. If it is basically the rules, regulations in the society, how actually one should deal with them when, be it with whatever law, be it criminal law, matrimonial law, civil law, estate planning, anything. And then that's what drew me more towards law, and then I became more interested. And of course, when I cracked few of the exams and I finally landed up in the law college, I the journey just began, and understood that the interest keeps on developing with each day. Today also, I cannot say I am somebody who knows the law. I'm still studying, and I feel I will say this when I'll be, say, 20, 30 years down the practice also. I will still study the law because law is such a dynamic concept that it keeps on evolving with time, and at the same time, the basic fundamentals would remain the same. So that's what drew me to doing law, and I'm so glad and happy that I chose the field which interests me. And not even a single day goes by wherein I'm intrigued and interested more or learn from my career. So a good choice, I would say, that I made for myself.
Yeah. So it is quite a tryst with destiny that you became a first generation lawyer.
Yes, I am a first generation lawyer, but yes, there are struggles of a first generation lawyer. It's difficult. If you ask me what are the challenges, it's difficult to get hold of what to do, when to do, how to do. So it's all hit and try that we try. Oh, this works, this does not work. This is how we deal with the client. This is how we prepare for a matter. But it's all a process. We are student of now. We learn every day and we evolve every day. So
Correct. So you set up your own chamber in 2018. How did that experience shape your approach to interacting with the clients on deeply personal matters like estate planning?
right. So when we deal with a client, firstly, we have a chamber. As especially as a first generation lawyer, you start from the very scratch. You have a small size room. You have one table, two chairs on one side, one chair on one side. Client will sit there. You have no associates. You have no helping hands with you. You yourself are the one man show who's dealing with the clients initially. Once come, they discuss the problem. You deal with the client. You have a client meeting, and then you whatever possible avenues, if you know of the recourses, strategies, you tell the client right away. Else, you tell the client, oh, I need some time to look up on it. And then I'll get back to you, and then you advise them legally. And then, whatever recourse is available, you act upon it. Having a chamber, eventually, you'll get to have helping hands, be it interns, be it associates, be it building a good team, and then having strategies, hierarchy over strategies. The first meeting will be done by the associate level, then the brainstorming will happen at the associate and the senior associate level, and then ultimately we'll develop on the strategy. That's how we go about it. Uh, if I talk about my journey, when clients you come to us, and in fact, even today when they come to us, we understand what are their needs. So they'll tell us a lot of problems, they'll tell us a lot of facts. They'll say this happened, this happened, this happened on this date, this happened. And then ultimately towards the end, we need to first understand what actually client wants. So while the client is telling so many facts to you and so many problems to you, one should not get disillusioned or confused as to what can the appropriate recourse be. For example, let me tell you, today only one client walked in our chamber who was telling about her case. Her case is very simple. She married, she started living in her in-laws family, and then eventually her husband died. So she left that family and started living at her parental home. Because of certain difficulties, her children are still at the in-laws home because her place of work is nearer to her in-laws home. Now she is not living herself at her in-laws home, she is living at her parental home. However, her children are still residing with her in-laws. Now she is not getting maintenance from anywhere. She is not getting it from either in-laws or from her own family. And she came to us that what should I now do? What case should I now file? So while hearing to her story and hearing her facts, one should not jump to a conclusion, we should file this case. This is the most appropriate recourse for you. That is not how one should be. We need to first understand what are her actual requirements. Does she really want to file a case, or does she want a sustenance, a maintenance, or some sort of monetary compensation on monthly basis? Or is it
Correct.
she is wanting that she wants a share in her own family, the parental home? Or is it something that she wants a residence to live in, be it at parental home or matrimonial home? So what are her requirements is something we should first think of and then suggest the recourse. So sometimes what happens, we get to know a lot of facts and we see, oh, these are the facts appropriate for filing a domestic violence case. Oh, these are the facts appropriate for filing, say, a senior citizen complaint when suppose a senior citizen comes. So we should not be in a hurry to at least file a case or suggest a case. We need to identify, recognize what are the client's requirements and then accordingly suggest is the appropriate recourse. So that's how we have gone about it. Fortunately, it's working. Fortunately, clients will ultimately get what they want. They are more than happy. They are not bothered whether you have filed 4 cases or 5 cases or just 1 case. If you are able to give them the result, what they are actually wanting, that's what satisfies them.
Okay. So do you follow the same approach when they come to you for estate planning, or the approach changes a little bit?
So some clients are far more aware, or they have identified what they want when they come to us already. So suppose a client will walk in and say that I want to I want a will to get registered. Will you draft a will and get it registered? So I'm believing this client know what will is. This client know what are the consequences of making a will, and he has now identified his needs, and that's why he's coming to us. Some clients come to us and they are really not aware as to what they want. They come with their problems and they tell the problem. So, for instance, suppose a client had come to us who is having a matrimonial issue with his wife. So, he is now scared that tomorrow, whether divorce takes place or not, they are undergoing matrimonial discords, and there are multiple litigation between the husband and wife. So, what his concern is, tomorrow, if I die and I have not yet gotten divorce, then will all my assets go to my wife, or will she have a share in my assets? One query is this. Another query is that suppose if I get a divorce and then if I die, then will my wife have a share? So he has concerns, but he doesn't know how his concerns will get resolved. That's where a lawyer should step in, and that's where a lawyer should guide the client. That see, your entire difficulty will get solved if you make a will. In Delhi, if you get it registered, you need not even go for probate proceedings. So the question that you're asking, that whether we follow the same pattern when a client comes to us for estate planning, answer is yes. But depending on what the client wants. Now let me give you another example. A client was already undergoing a settlement talk for mutual consent divorce with us. Now this client had clarity, had gotten a will with regard to his properties and assets long time before when they started with their matrimonial disputes. Eventually, they entered into memorandum of settlement that yes, these are the terms of settlement. The child will remain in the custody, let's say, of the wife. Let us assume I am representing the husband. Now the husband is having concern, tomorrow if wife dies, then I being the natural guardian, even though the memorandum of settlement is saying that we are not sharing joint custody, the sole custody lies with the mother, then at that stage can I claim custody of my daughter or my son, whatever the case. Now this is very interesting. There is no terms in the settlement agreement which defines as to what will happen if the who's having the custody of the child is no more. And let us say the mother has died intestate. Then what will happen in this case? And similarly, vice versa. Let us assume our client is having the custody and unfortunately the client passes away. Then in that case, can the opposing party who has already sought divorce, in the terms of settlements already mentioned that she will never have custody, but now she becomes the natural guardian. So as a natural guardian, she can have the custody of the child. She files a petition, say suing the grandparents now that I am the natural guardian and I wish to have custody. Grandparents memorandum of settlement only barred her from having custody. But at the same time, I will come with a excuse or with the reason that no, that was during the lifetime of the father and not after his lifetime. So then what happens? So then in that case, in such scenario, we always recommend our clients that you also put a clause mentioning in case the child has not reached the majority, then in that case, to whom will the custody go? Or if you want some assets to be disposed of. Now in this case, consequently, even assets disposal will become a problem. Father has died, only child is there, there are no grandparents, there is no other class legal heir apart from the mother. Child is still a minor. Let us assume there is some relative who need to take care of the custody of the child. But still, assets still is a problem. Now wife is come. Our Karishma Kapoor case, the same thing happened. He had sought. And now even after divorce, even after settlement has taken place, she is taking, it was there in the news that she is wanting a share in the husband's property. So then what will happen? So then in that case, whether to give it to a trust, if you are making a will, should it be given to a trust or should it be given to an individual? Let us assume that another client. Let me know if you want me to stop giving examples, because there are a lot of clients who keep on coming in and we can go on and on. There's another client who had come and that client wanted that the property should go to the children. But of course, he's uncertain whether he'll be living until the children will attain 18 years or not, because you have to see all the circumstances. So then we recommended the client, if you are unsure that tomorrow, let us assume you are not there. Children have not attained majority. Mother being or father being the class 1 legal heir. Then that person will get hold of your properties for the benefit of children till the time they attain 18 years. So which means, suppose husband is having custody, wife is not having custody, husband dies, property goes on to the children, it's written in the will, but children being minor cannot operate on the properties, they cannot transact the property, they cannot sell the property, purchase any property, because they are minor. In the eyes of law, they are incompetent to enter into any sort of contract. Then in that case, mother can always come in and say, I am the natural guardian. Let me operate the properties. Let me handle their bank accounts. Let me see if the property needs to be sold in order to meet their expenses. If that needs to be done, I'll do it on their behalf. And then there's always an issue of trust between the spouses
Correct.
already
Correct.
taken divorce. So then in that case, what needs to be done? Then we can always form a trust and tell that this trust will get hold of all the properties for the benefit of the children. Trustee can be somebody, beneficiary can be the children, and then the trust will operate all the properties for the children until they attain 18 years. And once they attain 18 years, then the children become the sole and absolute owner of the property. That's also one way to go about it. So that's how we handle our clients when we deal with them.
Yeah. So these type of cases are increasing day by day. And as you said, you have a lot of people coming in with such type of problems. So what are the first practical steps you take relating to documents and legal formalities that are very essential to starting the process of estate planning?
Right. So that is the most cumbersome, I think, process which a client feels when they step into a lawyer's office. They feel so many documentation will be asked, and many a times it happens that clients don't even have documents. For example, a client walked into our chamber and she said, I want partition of the parental home I am staying in. She was not married, she was bachelorette, and I want partition of my house. I have been thrown out of my house by my brothers. This property belonged to my father and mother. Both of them have died now. So I said, okay, fine. In order to file a partition suit, you need to attach the property documents. She said, I was thrown out of the house. At that time, I was very much scared. I had nobody to support me and not filed any police complaint also. So ideally, if she was thrown out, she could have always dialed the police number, be it whatever. In Delhi, we have 112, and she could have said so that all my belongings, including original documents, Aadhaar card, all my identity proofs are kept in the home, and then I've been thrown out. This was my parental home. I've been living here since so long, and this amounts to NDV Act, whether it will amount to cruelty or not, whether that was a domestic household or not, we are not going into that. But this is creating a lot of difficulty and hardship on me. And always better to have all your documentation, e-copy also, so that cases like these, you always have at least a photocopy of the document. So she said, I have not lodged any complaint. I want partition, and I don't have any documents to show that my father and mother are the owners of the property. So the first difficulty we face over here is she doesn't have the documents, which becomes the basis of her filing any case in the court. So court always believes documentary evidence more than oral evidence. Of course, there are provisions now. We can ask for production of documents. We can ask the defendants to get those documents. Of course, defendants will not deny that this was the property belonging to their parents. But it's always advisable that you carry all your documents with you, be it in hard copy, be it in soft copy. How we go about with the clients is, firstly, when they are coming to us, we take a briefing, a thorough briefing with them, and in a chronological order. Tell me date-wise what happened. If some clients are not very much good with the dates, we tell them beforehand that when you are coming to us, we'll sit with you. We'll discuss all your events, line-wise, chronological-wise. And then, after understanding again what's their problem, we ask for supporting documents qua each event. So suppose they say mother or father had purchased this property. So I'll not just ask for property in which mother or father has bought it. I will ask for the entire chain of documents. From the time when this property was given, say, by the municipal corporation or say development authority, first allotment which has taken place, the conveyance deed usually, I will start from there and then I will go line wise to each document. From say, let us say in 1980, this property was purchased, say, by your great grandfather. Then after great grandfather, he died. Did he leave a will? Did he leave a registered will? If an unregistered will, did he make a probate? If not a probate, then how did this come there? Was there a partition suit filed? Was there a decree of partition? Was there a oral settlement deed formulated into writing later? So all of that. So it's necessary to have all the documents what the clients have from the very beginning, and the entire chain should be thorough. It should not be so that in between some years chain we don't have. Oh, that is lost somehow. If it is lost, then where did it go? So another client who had come to us, there was a suit with regard to declaration of title. Two different parties, plaintiff and defendant, both of them claim themselves to be the owner of the property. And this is a suit for declaration of title. Now what is happening? Till say from point A till point B, both the parties have common sale deeds and whatever documents. They have the common documents, and from point B onwards till they getting plaintiff getting his document title change and defendant getting his document title change differs. Now the crucial aspect of here is this B point. Who is the owner at point B? Now this person has left for heavenly abode. So now we can't call this person. So now we call somebody from the registrar office, because it should be a registered deed. Any immovable property when transacted, Registration Act compulsorily mandates that that document must be registered. If registrar has also has died, but that document still remains on the records of the registrar. So that is how you should always collect documents from your clients, chain of documents, and best possible evidence. Evidence Act says so, that you should always ask the clients where are originals.
Correct.
So interestingly, in one of our cases, this is at the stage of final argument, another matter dealing with civil suit, declaration of title and possession and permanent injunction. While evidence was going on, so what happens in a case? At the stage of cross-examination and chief examination, parties are required to mark exhibits and mark, which is basically identifying which are the original documents and which are photocopy in the court record. So when defendants were representing the plaintiffs, when defendants' evidence began, at that got the original documents. It was so interesting to see that in the originals, the signatures were missing on one of the parties. But the written statement which they had filed, along with that, the documents which they had filed had proper signatures of both the parties. So we requested the court, let this original be there and let this not be exhibited as OSR. OSR means original seen and returned, which means court has seen the original. Court will not keep the original in its court record, because this document might be useful for the party for future references, for future purposes, in order to deposit it elsewhere. So we told the court, this is something which is done deliberately with the defendants. They have signed it later, possibly on a photocopy, and then they have filed the photocopy before the court, because initially it's not necessary to file your original documents. So that's how we can know that clients might be telling you in good faith that they have documents, they have appropriate documents, but when you actually look at their documents, you'll realize, oh, this was not the correct document. Another client came to us and they said that this is the will. Now, the front page of the will had the testator's signature and one witness's signature. Now, it is mandatory in a will to have signature of two witnesses. Now, the second witness, when we asked where is the signature of the second witness, and when we turned the page, it was a blank page. So they said, oh, we have forgotten the second page at home. It is at home, we'll get it next time. And the next time, the document which they got, the first page was little yellowish in color, because it was an old paper. The second page was very much white in color, and we ourselves could make out that this is not a continuation of the previous page. So obviously we told the client that you may look at it, we feel this might become suspicious for the court to believe. You want to file a probate proceedings for this, we can do that, but this might get questioned during cross-examination. If we ourselves can see it from our bare eye, the defendants will also be able to see to it. But then, of course, I mean, we can always advise the client. It's ultimately the client's decision. So that's how we go about taking client briefing. Event-wise, chronologically, take the briefing. Then corresponding documents must be taken from the client. If possible, see the originals. And then accordingly, we can proceed with filing whatever recourse. It is not necessary that every time our client comes to us, we have to go and file a case. For example, a client came to us and said, I am unable to get my electricity meter transferred in my name. So I said, okay, so what is the difficulty? She said, my mother has expired. We are 3 sisters now. Now 3 sisters, we are living in 3 different floors, ground floor, first floor and second floor. All of us are not disputing that our mother has now expired. Father expired long back. The property was in the name of the mother. Mother has left a will also, though not a registered will, but a unregistered will. She only wanted a change of electricity connection in her own name. So there were 3 meters already installed at the ground floor for each floor. So ground floor, first floor, second floor, each had 3 different electricity meters. So somebody advising the client that you please go and file a suit for declaration or suit for injunction against the electricity board to get your meter changed, I don't think so. That's a wise decision. A simple NOC, which is a no objection certificate required from the owner, will suffice. A surviving member certificate issued by the revenue department will also suffice to show that after the mother expired, father had expired already, and only 3 daughters are there as the class 1 legal heirs, and there are no other class 1 legal heirs. Therefore, these 3 are in possession of this property, and each daughter will give NOC qua the other 2 floors, and all 3 of them will get their name changed. So that is also one of the way to go about it. It is not necessary that you have to rush to the court to get the relief. As I said, we need to understand what the client requirements are and accordingly advise them. So this is far more quicker than a court case. So that's what will give the client also satisfaction that had I fought this for 4, 5, 6 years, even though if a court case would have been filed, the defendants would have come and said, we have no difficulty. Rather, they were also the ones who were wanting a NOC and the electricity meter to be issued in their name. Court would have also called for a SMC. SMC is surviving member certificate. These 3 would have to go to the revenue department to get the SMC, but it is far more time consuming, which could have been easily done, say, in 2 months. Would have taken, say, 2-3 years. I mean, we can't comment how long. But then this is far more quicker, expeditious, and more satisfying for the client.
So true. So your approach depends upon what the situation is and like what relief the client actually wants. And it's just so interesting to hear you talk about real life situations that you encounter, and also how lack of a single document can change the entire course for the customer who comes for a relief. So people often use probate and succession certificate interchangeably. Could you please differentiate the two for our audience, because there is a lot of confusion as to in what situations a probate is needed and in what situations a succession certificate is needed.
Probate, succession certificate, letters of administration. All 4 are dealing somewhere with the estate planning. Possibly lack of estate planning also. Because planning is not done, that's why now we are rushing to the court to get the damage control done. So I go one by one for each concept. Will is something, so let me start. You have asked for probate and succession certificate, but let us first start from the will and then we move on to, because will is the basic first thing that what one can start with. Will is something if a testator, if a person who's wanting to execute a document defining as to what all assets he has, it is not necessary that you put forward all your serial wise all your properties in it. It is not necessary. You can simply say all my movable, immovable properties, and that will include all the properties till the time of the death of the testator. So let us assume A has property XY only at the time when he has made the will. Subsequently, he made a will, say, at the age of 60 years. He lived, say, till 80 years. He acquired a property Z also during the last 20 years. That is after making his will at 60 until he died at 80. So, when will come into operation, will only comes into operation after the death of the testator. So, it will come into operation at the age of 80. Not at the age of 16, that is when he has drafted or executed the will. That is not the date when it comes into execution. This is also sometimes some people have some misconception. If I make a will today, oh, all my property will go away. So that is not so. This is you are safeguarding your property from going into the hands of somebody else whom you don't want to have after your death, not during your lifetime. So the will come into operation now, not just qua X and Y, but also qua Z. Why? Because he has acquired Z during his lifetime. So first is this. Will is something a testator would execute. Testator would sign before the registrar office at his home. That is again not a difficulty. The privileged wills, there are unprivileged wills. Privileged wills are the wills wherein, say, a soldier or an airman at the time of war we can understand that he is not going to live long, so he is possibly going to die. He puts a will, say, on a piece of paper, say, on a stone, anywhere, and then that will act as will. He will not have two witnesses, which is ideally required for will to be a valid will. Generally, unprivileged wills, which is the usual case which we see, is the will wherein a testator writes down everything that after my death it will go, so and so property will go to so and so person, so and so property will go to so and so person. It is not necessary that the will should go in the name of the relative or class 1 legal heir. If A wants to bequeath his properties, say to the government, say to a beggar, say to give in charity, he can do that. There is no bar. So that also is sometimes a misconception. I have 2 daughters. I don't want to give to one of my daughters. Is that a valid will? If I give it only to one of my daughters, that is absolutely valid. It is your wish. That is why it is called as will. It is your wish. It is your will. Wherever you want to give, you may bequeath your properties. Second requirement for a valid will is that it necessarily needs to have 2 witnesses. A single witness will is not a valid will. Sometimes people file a probate petition. Probate is basically a validation of the will which is filed on the basis that it has only one witness. And the first question which the court at the time of admitting the probate petition asks, this will only has one witness. How can I admit it? This is an invalid will. So it needs to have at least 2 witnesses, can have more also. Third requirement which one should take care of is that this witness should not be a beneficiary in the will. Let us say a father gives property to 2 of his sons, A and B. Makes them as witness in the will because he has no one else to go with to the registrar office for signing as witness. So he takes both of his beneficiaries to the registrar office, both of them sign the will. Oh, we have seen our father signing the will in front of us in the registrar office. Now, sadly, both of them will get nothing after the father's death. Irrespective, if I talk about intestate succession, possibly there they will get it because they are class 1 legal heirs. But as per will, they will not get anything because they are the witnesses and they are also the beneficiaries. So,
Correct.
if a witness is actually one of the beneficiary, that witness will continue to remain as witness. That witness cannot say, I can choose. I can become witness or a beneficiary. Let me become beneficiary. Sorry. You have now become witness. You have ceased to become a beneficiary. So those are majorly the requirements of a valid will. Of course, the testator has to be of sound mind. A testator cannot be of unsound mind, insane at the time of execution of the will. But of course, once sound mind, it is established not under any force, coercion, misrepresentation, undue influence. If it is made as per the Indian Contract Act, all the requirements which are there for executing a contract are valid, then that will is considered. Now, one of the benefits of a will getting registered in some of the states is that it need not get a probate petition. It is not mandatory for one to file for a probate petition.
Okay.
Come to what probate petition is so that we understand the last statement that I said regarding will. Now, probate petition is something like a validation from the court that this is the last will of the testator and this will is the final valid binding will. So let us say Mr. X executed 3 wills during his lifetime. There is no bar, however many wills one wants to execute can execute. 1 will, 2 will, 3 will. Say on daily basis also, if somebody wants to change the will, can change. And will is very interesting concept. Though as soon as you execute a subsequent will, your prior will gets automatically invalid. So your last will prevail. So if X has given, say, a property to Mr. Y, and then subsequently X has given that same property to Mr. Z, so will in which Mr. Z is getting the property will be the final will. Z will enjoy property, Y will not enjoy property. Now there is confusion or there are 2 wills. One will is registered will, one will is not registered. Registered means you go to the sub-registrar office and there the officer will authenticate, oh yes, testator is standing in front of me, he is the same person, he is of sound mind. They'll ask few questions and once satisfied, they'll ask the testator to sign. We'll also have 2 witnesses in front of him. We'll see, oh, these witnesses are not influenced by the testator, they are independent witnesses. It is always better for the registrar to inform that you cannot be a beneficiary. If you are a beneficiary, better not to become a witness. And then once all the signing is done, a registration number is given to each will, which is entered in their own records in the book number, volume number, registration number, page number, all of that is mentioned. And it becomes a government document. Will is a document which cannot be procured by anybody. It can be procured only by testator or by the beneficiaries or by the witnesses. So somebody says, oh, I have taken out the will of XYZ. Sorry, not possible. Ideally, of course, there are ways people can manage to get a will unofficially. Now, coming to probate, so there's a confusion that he has executed 3 different wills. Now, which one will prevail? Which one should one follow? So, in first will, A is getting benefited, second will, B is getting benefited, third will, C is getting benefited, all of them regarding one property only. Now, all of them are fighting, oh no, this is my property, this is my property. So, the executor named in the will, the concept of executor is somebody who has been assigned the duty that you are the one who will take care that all the properties are given to all the beneficiaries in the proper way as it is mentioned in the will. Executor can also be a beneficiary. It is not necessary that executor has to be a third person, independent person. No. If a will is given beneficiary, there are 2 beneficiaries, will is being bequeathed on 2 persons, A and B. A can be an executor, B can also be an executor. Some will state that A and B are executors for their own shares, which means that after X dies, the testator dies, then if A is the executor, A will have right to file a probate before the court. B cannot, as a beneficiary, only beneficiary and not an executor, cannot file probate in the court. And if suppose an averment is that A and B are executors for their own share, which means now A and B both can go to the court and file a probate petition. Now coming back to probate, probate means that this is the validation from the court. Court will look into it. Court will see, irrespective whether registered, unregistered, court will examine the will, the contents of the will examine the witnesses, will publish in newspaper that a probate petition has been filed for XYZ will of this testator. Are there any other legal heirs or anybody objecting to this will to be declared as last valid binding will? If yes, then those objectors are most welcome. You please come forward and put forth your whatever story it is. Suppose a newspaper publication is made and then somebody comes and says, oh, this is a property which is my property, this is not of testator, this should not have been mentioned in the will. Now this objection will not sustain. Why? Because court is not actually declaring that. Suppose, let me give you an example. I put in my will that I have Taj Mahal, Red Fort and Qutub Minar as my properties. Let us assume I have made this will and I have gifted all this, I've bequeathed all these 3 properties to Vaishnavi. Now, say X is the executor. Or let us make it simple, you are the executor. You rush to the court. I've got all the three things: Taj Mahal also, Qutub Minar also, and Red Fort also. You rush to the court. Now, court is not going to say that Taj Mahal, Qutub Minar, and Red Fort are government properties not belonging to Mansi. Court is not there to see whether the contents of the will are valid or not. Court is there only to see whether Mansi's will is the will that is in question, is the last and final will or not. Whether this will was made in sound mind or not. Whether this will had two witnesses or not. If somebody else is objecting that no, Mansi had another will, another subsequent will, and that will is actually the last and final will, this is a prior will. So then court will examine only this question. Court is not going to sit and decide that whether this property was actually testator's property. Suppose tomorrow Vaishnavi files an application. This happened in one of our matters. We are resisting the probate petition. We are for the defendants. Petitioner filed an application that this property was, there were 4-5 properties. One of the properties is mentioned in the will and I want to sell it off. So court said, I am not the one who's going to give you permission. I am not the one who's going to actually authenticate whether this property belonged to testator or not. That is a subject matter of some other case, which is say a suit for declaration, or if it is challenged, then suit for whatever the case may be, cancellation of title deeds, whatever the case may be. So a probate petition is filed for authenticating that the will which is there in question is the last final valid will. That is what the probate petition is for. Now coming to my statement that I said some time ago, that registered will in some states, it is not necessary to get a probate petition for them, get a probate for them. This is a Clarence Pius judgment of Supreme Court, which says that only some states, say Bombay, Madras and Calcutta, I believe, are the 3 states wherein it is necessary, even if it is a registered will, it is necessary that you have to seek a probate from the court. That is the final stamp of the court, basically, that this is the last final will. In Delhi, we always advise our clients that if you are getting your will registered, then there is no need for probate. So that's an added advantage. Your beneficiaries will not have to run to the court. They'll not have to pay the lawyers. They'll not have to incur that expense. Now the third category, and just quick, though very unusual, we have never encountered it. Unusual category is the living will. Basically, it's a will wherein a person says, I wish to die with dignity. Which means, if suppose the testator somehow lands up in a vegetative state, say sometime in future, then my line of treatment would be this. I would kindly not put me on ventilator, not treat me medically, let me die peacefully. So that is a living will. So that basically deals with your medical condition. So that is also one sort of will what one can always put forward in their, mention a clause in their own will. Now next category that we talked about is the succession certificate. Probate is majorly for the immovable properties. A person who is owning immovable properties, who has made a will, has died in testamentary succession. That's basically a testament is made. Then probate will work. There are judgments to the contrary also. If one starts finding can for an immovable property, say for bank account, say for security, say for debt, can probate be filed if there is a will? Answer is yes, there are judgments on both sides. But succession certificate is primarily for your movable properties, not for immovable properties. First line of difference between probate and succession certificate is this. Second line of difference is that there is no will. That is why A has died. Now A's sons, daughters want their own share. They are very puzzled what to do. Should I file a suit for partition under the Hindu Succession Act? Or should I go for succession certificate? Which is basically A died without leaving a will. A only has bank accounts. And now those bank accounts amounts lying have to be divided between the legal heirs. Then they will file for a succession certificate. They will not file for a probate because probate, you need to have a will. Succession certificate, it's okay if you don't have a will. Now, let me assume somebody has a, and I'm so sorry, for probate, I believe I had said so, executor is the one who has to go and file a probate petition. If executor is not wanting to now act. Executor is, say, a third party, neutral party who's least bothered if a testator has died. Then in that case, beneficiary can also file probate petition. There are judgments to that also. In succession certificate, only legal heirs can go and file for succession certificate, because they being class 1 legal heirs or they being the class 2, as the case may be, they being the legal heirs are now wanting the division of assets of the dead person to be divided amongst themselves. So that is the difference between succession certificate and probate. Now, last category that I said was letters of administration. Letters of administration can be for both will and without will. There is no confusion with regard to that. The difference for letters of administration, probate and succession certificate is letters of administration are only giving you rights to administer the property. They are not giving you absolute rights for the property, which means it's sort of like a trustee, which means that you can now look after the property. If need arises, you may sell it off. But tomorrow, if there is a claim that no, I am the owner, then there will be a dispute. Even though a person who has got letters of administration, he has got right to administer the property. So we always advise our clients, as the case may be, to file probate or succession certificate. There have been, once it has happened that we have filed letters of administration. Procedurally, all of them are same. Procedurally, as soon as petition was filed, one has to undergo the newspaper publication. There is a report called from the subdivisional magistrate's office or the revenue department, as the case may be, asking for the valuation of the property. Accordingly, court fees towards the end is paid. Once a probate, succession certificate or letters of administration is granted, evidence is done. If there are objectors, then obviously they will have to prove their case. Petitioners will have to prove their case. If all of them are on one page, if there is no resistance from the defendants, respondents, then in that case, they may file their no objection, and court, upon being satisfied that this is the last final will, or there was no will, or there is a will quasi movable property, whatever the case may be, will grant probate, succession certificate or letters of administration.
Also, I want to understand what kind of amount is to be spent in order to obtain these certificates.
So, at the beginning, many times clients say it is they say we don't have money. So, what we do, we say initially let us file the petition with 200 rupees court fees. Ideally, a probate petition, let us talk about it. Ideally, probate petition, the entire market value of the assets. That's why I said a SDM report is called, which means SDM will actually go value. This is the value of the land as per circle rate, as per market rate, as the case may be. Circle rate rates are usually mentioned in the SDM report. And whatever, say 1 crore, 2 crore, 3 crore, whatever valuation of the property is found out, based on that, our Court Fees Act and Suit Valuation Act prescribes for fees. So let us say 3%, 4%, 5% can differ from state to state. Suppose 1 crore is found out. So then based on that 1 crore, 4% of the amount will be your court fees, which you will have to pay at the time of obtaining this probate certificate from the court. It's far more expensive. That's why I said it's always better to get a will registered, especially in the states apart from Bombay, Calcutta and Madras. In Delhi, if we are based in Delhi, we always tell our client, get your will registered, because the expense what your beneficiaries will incur after your death, that is far more higher than what you will incur in getting it registered. So that is how we go about it. Of course, there are provisions for showing that you are an indigent person under Civil Procedure Code. One can always apply for that. But then usually when the estate is going to get involved of beneficiary, court can always say from that estate you may pay so. But again, the concept of indigent is very interesting, because filing the suit whether I had means or not as if I am rich in future. So that should not be consideration for court. But I am not seeing any probate or succession certificate applications being allowed without filing any court fees. So minimal court fee 100, 200, 20 rupees. Once we did a matter in Ghaziabad regarding acceptance certificate, there were bank accounts, there were mutual funds, there were shares, there were certain FDs, all amounting to some lakhs. Let us assume 50 lakh rupees. So we filed that acceptance certificate application with only 100 rupees court fees. And we said we undertake to pay the same when this court will be granting me the succession certificate. Prior to that, I will pay the entire court fees. So once the succession certificate was ordered in the favor of the client went with the court fee, stamp duty, he paid the stamp duty, and then he obtained the succession certificate.
Interesting. So now that you have been practicing for quite some time, what are the roadblocks you often encounter in court proceedings? Maybe it procedural delays or documentation challenges or unexpected claims. What are the most common roadblocks you come across when you are filing these petitions or maybe disputing? You are looking after the disputes.
Right. So let me again start with an example. Recently, a client came to us. One may think that whatever we are talking about is purely, say, matrimonial or say related to civil matters. Let us clear that misconception also. Recently, a client came to us. This is a labor matter. This has come to us. So a company had certain labors. So these are daily labors or say the contractual labors. They had filed a suit for minimum wages or say deficient wages. And they had procured an award from the labor court. Now, this award went into, not from the labor court, this was under Shop and Establishment Act. So, there is a designated authority for Shop and Establishment Act. And after that, this went to the executing court, one of the district courts in Delhi. Now, in execution, the person who was the director, the husband, has died. Wife is not a director. She doesn't know who the director of the company is. Company is a separate legal entity in the eyes of law. She comes to us and she says, I have got this execution petition summons with me. It is mentioning that 26 lakhs are payable to the workers. There are say 13 total workers. And now what should I do? So when I started questioning her, she said, oh, I don't know what's the exact company's assets. What is the property on which this company was running? Whether this property is a rented accommodation or was the asset of the company. After my husband died, who's now the director of the company? Whether on record, whether I was ever shown as director in the company or not. So procedural roadblock over here is, in order to resist an execution petition, now I don't understand why the summons are sent in the name of the wife if she has no concern with the company. Definitely that means that at least workers would have said that she is one of the directors in the company. That's why summons are coming to her. Or second possibility can be, since husband has died and the address is still the same on which she is residing, therefore the summons sent to the husband are now received by the wife at the same address. But interestingly, summons actually mention the name of the wife, which means she certainly has some role in it. So two possibility, whether client herself does not know, she does not have document with regard to whether she had any role in the company or not. Or second is whether the workers somehow misguided, misinformed, they were themselves misinformed, misguided the authority, that wife is also one of the directors. Now in execution proceedings, we have to first see what happened in the trial court. So roadblock that we are talking about over here is that clients won't have enough information and documentation to prove that what is the exact factual situation. One is this. Second roadblock that we face is, now when I went and tried procuring the trial court record is now lost because this is a 20-year-old matter. Somehow it was lost in the files, went in cold storage. Now they don't have the file. Somehow they were able to procure the file, but it does not have all the order sheets. And it also does not have the summon reports. So summon reports is basically when the court summons somebody, a notice is sent, and then there is always a report called back. What happened to this notice? Whether this person was served or not served. So summon reports are now missing in the trial court record. How do we ascertain whether husband was ever served or not? How do we ascertain what findings did the authority come to in order to ascertain that wife is also guilty in this and therefore execution proceedings should start against the wife? So this is one of the examples that we have seen. Now this is not with regard to civil matter, matrimonial matter. This is purely a business which was there. And based on the, say, winding up of the business or of partnership firm, this has now resulted in somehow a state litigation. So we are certainly of a mindset that, oh, estate planning means civil matter. Estate planning means matrimonial dispute. It is not so. And let me give you another example. There were husband and wife. They were dealing, they had a professional setup together. They were running a partnership firm. Now, obviously, there's some matrimonial discord between them. They are landing up in disputes. Apart from whatever matrimonial disputes they have, they are also facing difficulty with regard to distribution of assets of the properties acquired by them while they were together in their joint, in their partnership name, and in their whatever company they had formed. How do you divide these three categories of assets amongst yourself? So again, this is a partnership firm that I'm talking about. Now they will face a difficulty here. Another matter, husband and wife both very much enthusiastic of share market. Wife excellent at mutual funds, husband excellent at share market. Both of them acquired lot of assets and lot of stocks and mutual funds during their matrimonial relationship. And they took loans, they showed in the books of account, the entries are quite complex. Some things were shown as some other property, some person's property. Husband's share was shown in the name of wife's agent who was dealing with mutual fund. So it's quite complex. Now, how do you disintegrate all this and how do you put it forward in the court in order to make it sound simpler? So again, another roadblock over here is documents are not there. Now, this is not with the court procedure. This is with regard to the roadblock which we face with the client dealing. So this is again one of the roadblocks that we face. Now, with regard to court procedure, sometimes, as I said, you don't get the documents from the client which are quite clear in language. So the language is vague, language is quite crude. It's very difficult for us to understand and then to convince the court. So court will give a favorable decision only when a will state that will I have these properties and it is going to my daughter. Now if a testator says I will give it to my daughter and he has two daughters, now what court will decide on? So that again becomes a roadblock for us. Sometimes the roadblock is that court procedure is as such. Let me give you a very interesting example. We went for registration of the relinquishment deed by one brother in favor of another brother. The chain of documents, somehow, the name of the owner, let us say Manju, Manju, by mistake, in one of the documents it is mentioned as Manjoo. Now the registrar office is hell-bent that these are two different people possibly. So because of the spelling mistake which a typist would have done, these are typed documents way back in 1980s, 70s when there was a typewriter. So just because of a single spelling mistake, the entire documentation process becomes so cumbersome, it is almost impossible to get the registration deed because for registration deed, they want the entire chain of documents. So this is another roadblock that we face. And how to overcome this roadblock? You have to file a simple declaration that declares this Manju and this Manjoo as same person. So again, a cumbersome process. So though the registrar office is quite vigilant over here, they are looking at all the documents carefully, but this has become a problem for our client. Another roadblock that we face is that we want to summon a party, want to summon a defendant. Now, in one of the case, the defendants are staying in US. They are least bothered. They don't want to become part of the probate petition. They are served through WhatsApp and email, but still they are not appearing. WhatsApp and email service court is not agreeing because the service report for addresses, postal addresses, is still unserved because from India, if you send any summons abroad, it will take 2, 3, 4, 5, 6 months, God knows how long. You have to file complaints with police, with the postal office, and then after a lot of follow-ups, then it ultimately reaches there. So WhatsApp and email, and there are 3 defendants who are staying abroad. All 3 we had same number because they are from the same family, father and 2 daughters. Now court has asked us to send the summons through Ministry of External Affairs now. But again a roadblock. Even though they are served, even though we showed the court that they have acknowledged our message, they have said we don't want anything. Court is not accepting this as a valid mode of. So again, so these are little technicalities. Sometimes we don't know the person's address. Then we have to do the newspaper publication. Newspaper publication we have done already. After 2-3 years, that person somehow comes in. Again, we go back to the square one from the written statement. Now the trial will continue. Pleadings were filed, plain petition, whatever was filed. Now a reply will come to the petition. But these are procedural. I mean, this is something which a law has laid in. We can't go about it. We have to follow that. But these are the roadblocks that we usually face.
Correct. It's very important to have all the documents in the proper place to cross check whether your names are similar or same in all your legal documents. It's very essential because all these little mistakes can cost you a hefty amount, a hefty sum, can land you in struggles when you are no more.
Yes.
My final question to you would be, what key takeaways would you like listeners, especially families, those who are planning their estate, to remember?
My first and foremost suggestion would be please get all your documentation collected. Many times people don't know what bank accounts I have, where are its passbooks, what shares I had purchased, the mutual funds I had purchased, the folio numbers. They don't have that. Please get all your documentation collected. Second advice would be visit people like you are insured or advocates and show them your documentation and whatever your requirement is. It is always better to safeguard yourself than to land up in trouble later or than to leave your things unaccounted for which your beneficiaries are later fighting in the courts. Courts procedure are time consuming, money consuming, resource consuming. How much money that you spend in court, not even half of it or say not even quarter of it you spend by writing say a will. Sometimes witnesses who are mentioned in the will are even older than testator. So they have left this heavenly abode. Under 281, I think, of Indian Succession Act, it is necessary to get one witness deposed before the court. Witness has also gone. Testator is also now gone. Whom to now talk to? Whom to now ascertain from whether this will was a valid and genuine will? So things like these, some people who are well equipped, well known with the law, consult them, and then accordingly you can proceed with whatever recourse you want to have. And then once that is done, you are mentally sorted. There is nothing to worry about. So that's my advice to our listeners.
So, as we wrap up this conversation, one thing becomes very clear, and that is estate planning is not just about documents or legal formalities, I would say. It is all about love, responsibility, and the foresight to protect those who matter the most. A huge thank you to you, ma'am, for bringing such clarity and depth to this discussion and for reminding us that planning for the future is truly an act of care in the present. And to our listeners, if today's episode made you pause and think, let that be the beginning of action. Have the conversations, ask the difficult questions, and take the steps that will bring peace of mind to you and your loved ones. That's it from You Are In Short, and I look forward to joining you again soon. Until then, take care and remember the best time to plan is always now. Thank you.
Thank you.